Hello, my name is James MacGuill and I'm a solicitor practicing in Ireland. I've been asked to talk to you today about Measure 2012, number 13, otherwise and more commonly known as Measure B, on the right to information. The measure was adopted by the authorities on the 22nd of May 2012. And before proceeding further with the discussion of the measure, I might tell you a little bit about my own background so you'll understand where my particular view on the measure might come from. I'm a criminal defence lawyer practicing in Ireland. I have been active in the European Criminal Bar Association and am presently head of the Irish delegation to the CCBE. In those capacities, I've been involved in the development of the discussion in relation to procedural safeguards in Europe and across the European Union since the original introduction of the Commission's Green Paper on procedural safeguards many years ago. Colleagues will be aware that the view of Member States to the Commission's proposal was not wholly welcoming, and that a number of Member States in particular wanted to block the measure in its entirety. To my great regret, Ireland was one of those countries, as was the United Kingdom, Cyprus, Malta, and the Czech and Slovak republics. Because of the opposition of those Member States at a time when unanimity was required to advance matters, the Green Paper was effectively abandoned. However, during the Swedish presidency, the Stockholm Programme, or otherwise known as the Roadmap, was introduced, where it decided to proceed on the basis of introducing the measures piecemeal rather than as one comprehensive measure. The measures were originally intended to be measures A to E, but Measure C has now been broken down into Measure C1, the right to access to a lawyer, and C2, the right to legal aid. Today we're going to talk about Measure B, which is the access to information for persons suspected of criminal offences and in custody. By way of background, the situation across the European Union is that while there were individual guarantees in individual member states, not every member state enjoyed all the guarantees that were envisaged, and in particular in my own particular member state, we did not have a very well developed right of access to information at the point when our clients were remanded in custody or held by the police. So therefore it was with very particular interest that I looked to Measure B to see whether it would advance the position of defence lawyers and their clients in guaranteeing that they would have quality information available at the very time they need it most, namely while they're in detention and while they're being questioned. As we shall see, the measure ultimately adopted was compromised in significant respects, and while there is much to be welcomed in it, I'm afraid that the emphasis shown by the changes that were introduced indicates that a rather dilute approach has been preferred by the authorities in introducing the measure. Being Irish, I come from a rather unique position insofar as we have opted out of the competence of the European Union in justice and home affairs matters. In our case, and in the case of the United Kingdom, therefore, this measure is not a binding measure. So I feel ill-equipped to comment on the steps that individual member states where it is binding must take in order to transpose the measure into their national law. Experience in the past, of course, has been to the effect that the measures are not routinely transposed in time, and it may be that colleagues will want to look to the possibility of litigating the failures of their individual member states, either to transpose the measure or perhaps more particularly to ensure that there are effective steps taken in relation to the guarantees that have been introduced.